compliance program in corporate America is an effort to comply with criminal sentencing guidelines, the federal criminal sentencing guidelines, that provide you credit essentially toward a fine or some other kind of penalty if you have a program in place, an effective program in place, that's intended to detect and prevent corporate impropriety.
I did leasing for a good part of my law time, and I was doing a lease for an ad agency. I always liked to walk through their premises old and their premises new. In their old premises, there was one door that was closed, and I said, "What's that?" He said, "You don't want to go in there." I said, "I do want to go in there." He opened the door, and I took a breath, and I thought I near die. There's a man in there spraying fixative on drawings, some kind of pastel chalk drawings. And the air is heavy with this solvent. And the man's not wearing a mask, and there seems to be no ventilation. And he said, "I told you not to go in there." I said, "How can that guy do it?" He said he's used to it. Well, I told him the story of two executives in a photo finishing outfit that was serving jail terms for manslaughter because they subjected their workers to unsafe conditions. And I don't care how used to it he is, when he drops dead, you could end up in jail. Well, needless to say, in the new premises, they could not get a special flue pipe up, but they did put in 2 superventing fans and finally did find a substance that was not as offensive to human breathing as this piece.
If you get cold facts, or if in a business transaction it's all but a done deal, then it is very difficult to avoid some of the things that could have been prevented with a different plan, a different document, something that went differently in negotiations. And I think the other thing that happens to the lawyer, when you're constantly being brought in late, you begin to feel like a highly educated scrivener who is basically given 90% as a given. And then you're supposed to go off and do the last 10%, which is just fix up the document so that we'll have something enforceable between the parties. Well, there are some problems you can't fix in the last 10%.
Clients are gaining a greater understanding of the need for long-term thinking in prevention and other legal planning senses. The difficulty in many corporate environments is in the midst of extreme short-term profit pressures, there may still be a tendency to say, well, I'll put that off till tomorrow, and then tomorrow never quite comes.
Businesses regularly schedule their tax matter every year. They got to file a tax return. And one of Lou's great dreams was every time they file a tax return, they should also do a legal audit of their situation. And quite often they'll have financial audits, and they should have legal audits to see how they're handling their litigation, see how their claims are going.
Part of any transaction, you want to always look forward to what could go wrong and then backtrack and try to take preventive steps. And so frequently I'll raise the general issue of, well, these are some issues that can come up. Let's try to figure a way to prevent them.
One of the most interesting things that's occurring today is the recognition that success is not defined just as the success of reaching benchmarks in a document, but success is often found, and maybe importantly found, in having a relationship that actually works, where works is measured by what the client wanted to achieve. And so from the perspective of the lawyer as architect of transactions and architect or engineer of relationships, one of the lawyer's tools would be the ability to predict how this relationship will work, not simply whether the legal rights are being appropriately documented.
It's really essential to know and understand the client's business. It's not enough to sit back and just know the law without knowing the business and how the solutions that you propose will integrate into the business and what the client is trying to accomplish in general, what its business plan is, what its business goals are. Because if you don't know those, you don't know how to propose a solution. You can tell them what the law is, but you can't help them with a solution because you don't understand really what's motivating them and what their needs are. And that means that you are really no better than the books you read.
Opining from on high on a footnote in a Supreme Court case will probably not do a lot of good to a client who's trying to decide, do I sue, do I not sue? Do I settle, do I not settle? You have to translate your advice into their very digital thumbs up, thumbs down decision-making process. That's not to suggest that their decision-making process is simple. Quite the contrary. You are a small part of a very complex decision matrix in which the business client is thinking about product quality, financing, shareholder relations, employer relations, continuing contractual commitments, production availability and capacity. The business person is often thinking of things far beyond your ken when you're giving legal advice. And nevertheless, it's important for you to understand somewhat that extraordinary complex context when you tell him or her that it is advisable that you take a certain course of action or not.
To know the way in which the particular issue on which the lawyer has been engaged that day to work on behalf of that client fits within the larger context of the client's life, fears, hopes, objectives, concerns. And so those kinds of skills, both in lawyer to client and in projecting the way in which the client will relate to the world in which they live, those are the things that matter at least as much as technical legal skill.
Litigation of all forms, even among businesses, has a tremendous emotional cost upon the participants in it. And if that kind of cost can be prevented, we're all well ahead. Preventive law has a number of economic advantages. First of all, anyone who has practiced litigation understands how radically expensive that process can be. And if that kind of fight can be prevented in the first place, there's an enormous saving of economic resources.
At this stage in the life of the legal profession, clients need to know the importance of preventive law. Many of them only think, as many lawyers do, of the legal issues, and that is what law is all about. And the problem is that a client realizes that by his attorney spending a lot of time on peripheral issues, it's going to cost money. But I think we as lawyers have to be able to market to the clients the importance in the long run of preventive law, that it's going to end up costing them less and cause them a lot less aggravation.
People deserve to maximize their opportunities and to stay out of trouble whenever possible. And that, as a lawyer, that is your first and primary obligation.
Maybe preventive law is the kinds of things which lawyers can do that can help prevent people from being in trouble who needn't have been there.